Good afternoon, ladies and gentlemen. Today is March the 17th. It is now 4:06 p.m. and we will begin our discussion of the Housing and Real Property Subcommittee. Ladies and gentlemen, if you see absent members of the Housing and Real Property Subcommittee, it's because we have multiple subcommittees going on simultaneously, and other members of the ENT are in their appropriate subcommittee meetings that are going on right now as well. Today's discussion has seven House bills we're going to be discussing. And I'm going to present to you the list of the House bills and the order that we will be discussing them. And I will do that in just a couple of seconds because I see a couple of members from the Motor Vehicles Subcommittee logging on. So for those that have just logged on, I'm going to give you the bill order again. The bill order for discussion, ladies and gentlemen, is again as follows. Number one, HB 86, HB 878, HB 918, HB 1147, HB 1295, HB 551, and finally HB 140. Okay. All right. Thank you, ladies and gentlemen, for your participation in today's meetings. And we'll first get started with HB 86. We've heard HB 86 is landlord tenant rights and protections. We've heard HB 86 on a number of occasions, and there are amendments to HB 86. And HB 86 has a cross-file bill. I don't remember the cross-file number. The cross-file, I'm sorry?
Senate Bill 6.
Okay, so the cross-file is Senate Bill 6. And the cross-file of this bill has moved out of judicial proceedings. It is now in the position of the full Senate on the floor. There is an amendment that we're going to be discussing today where the Senate version does not have that amendment on it. The Senate is going to hold their version of the cross-file to wait for us to put in our amendment on the House side, and then they're going to adopt that amendment on the Senate side. And the amendment is an agreement between stakeholders. And Matthew, if you could take over and start to discuss the future. Let me back up. Matthew, have we previously adopted the previous amendments on HB 86?
I do not have, no.
We have
no record of adopting the existing amendments.
That being
actually, you know what? I'm sorry. I do have a note here that they were adopted. These are different now.
That's right. That's what I thought we had. So therefore, Matthew, what we need to discuss are the current amendments to HB 86, if you would, Matthew.
Sure. So the new amendment that you're looking at is contained to page, well, there are a couple different places, but primarily it's language in on pages 3 and 4 of the bill. The sponsor has requested to change a couple of the provisions with regard to what a prospective tenant would receive or may receive. There was some concern over what was meant by elements that compose the landlord's utility charges. This has now been struck and made a copy of the last 2 utility bills issued to the landlord. There was also concern over the language of information regarding billing, meter reading dates, service dates, etc., and whether or not it was practicable to apply or comply with that. So that language has now been struck. And a statement, and then the new language would allow a tenant the ability to inspect records retained by the landlord that document a bill for utilities. And if there's a question, I'm working off of HB 0086 133-021/1.
And just pause right there for a minute, Matthew. That document that Matthew is referring to also is dated March the 17th, 2022 at 9:48 a.m. It's at the very top of the document. So continue, Matthew.
Okay. There were two additional last minute changes that I had to do with handwriting, and I sent a copy of those out to the members, but I'm going to share my screen now. It came from the sponsor. So can everybody see the amendment?
Yes.
Right.
If you could, because Mr. Siliberti is a little bit older than I am, if you could expand a little bit for him.
Is that good for everybody?
That's good.
Right. Okay. So one of the recommended changes was, and I apologize to keep scrolling like this, I know it can be disorienting. At the end of the new language in subsection K, there was a request to add language, if any. It's a little bit wonky, this language, because it creates two conditionals. So the condition here is if the actual costs incurred by the landlord are less than the estimate provided to the tenant. And this is with regard to the amended language that allowed for estimates to be used as supporting documentation for retained security deposit amounts. So this provision only applies if the actual costs incurred by the landlord are less than the estimates that the landlord provided to the tenant with its supporting documentation. Then in that condition, the landlord shall return to the tenant within 30 days any excess of the actual, any excess amount of security deposit retained in excess of the actual costs incurred by the landlord. I'm not really entirely clear what, if any, adds to that statement. Because if there is no excess, then nothing would be returned.
Grammatically, I don't think it adds anything.
It doesn't. But yeah, but it doesn't hurt anything either, quite frankly. Who's is that part of the, okay, thanks. Any additional amendments there, Matthew?
Yes, there are
Okay.
on page 6, there are two changes. And this is with regard to the assembly provisions in the bill. This would, as I understand it, clarify that this right to assembly in a meeting room within the apartment facility that's designated for use by tenants or as a space to gather would be subject to subsection C1. Actually, I believe the intent might be to say subject to subsection C. I'm just going to scroll down to what subsection C is in the bill. This would provide that a landlord may not charge, or it's prohibited from charging a tenant organization any fee for the use of the meeting room for the first meeting of the tenant organization each month. This is existing language in the bill, but a landlord could charge a reasonable fee that's charged to all other individuals who are seeking to use this room. So I think it does provide a bit of clarification. However, I think that what was actually meant here was subject to subsection C.
It's C. It's C1 is that part you just read, and C2 is a reasonable charge for all other uses. Should this handwritten be just referring to C1, Matthew?
No,
No,
Mr. Chairman, I think the council is correct. It ought to be subject to subsection C.
The total subsection C.
Yeah, I think
Okay.
so.
Okay, as opposed to identify 1 and 2. Okay, that's fine. That's fine. Yeah. Anything else, Matthew?
No, those were the last set of changes that I had received on this particular bill, and these are all changes from the sponsor. The only one, again, that I'm unsure of the purpose is the addition of that if any language. I'm not sure what adding that additional condition does.
Let me get a motion so we can discuss these amendments, please.
So moved.
Second.
Second.
All right,
Second.
there's a motion and a second on the amendments. Any discussion on the amendments by the subcommittee members first? Delegate Wyville.
So all parties are okay now with this amended language?
Let's, Aaron,
Yes, sir. Yes, we are Delegate Weibel. Thank you. I want to thank the sponsor. I want to thank Mr. Mickler and the patience of the subcommittee. I know this has been a grueling exercise, but yes, we are good with the amendments and we have worked with the sponsor last night and this morning.
All right, great. Thank you.
Any additional questions on the amendments? Hearing none, all in favor of the, I'm sorry, Matthew.
I was just going to ask briefly because I believe MMHA had spoken to that if any language or had requested that if any language, and it might help the subcommittee to hear, because I'm not sure as to the interpretation of that or why it was added.
Yeah, I'm not sure it's necessary, to be honest with you. It's something that one of our folks came up with, and I don't think it, I think you and the chairman are right. It doesn't really add anything. It was for purposes of specific clarification, but completely understand if the way it's written that it's probably not necessary.
Yeah, I don't think it's necessary either.
I think it doesn't help. I think it's redundant.
Yeah, I agree. So we're gonna remove the if any, ladies and gentlemen. Other than that, are there any additional discussions on the amendments? Hearing none, all in favor of the amendments that were just discussed, signify by saying aye.
Aye.
All opposed, say no. On the bill as amended, do I have a motion?
So
please?
Move
moved.
favorable.
Is there a
Second.
second on the bill as amended?
Second.
Any discussion on the bill as amended? Hearing none, all in favor of HB 86 as amended, signify by saying aye.
Aye.
All opposed, say no. Any abstentions? The ayes have it. HB 86 is passed. We will now go to HB 878. And Matthew, if you could give us a quick review on HB 8, holy moly, HB 878, that'd be great, appreciated.
Absolutely. So this bill would establish a Housing Opportunities Trust Fund as a non-reverting special fund within the Howard County Department of Housing and Community Development. The fund generally must be used to promote equitable access to affordable housing for households of limited income within the county. So essentially the bill just establishes a fund.
Are there any amendments, Matthew?
No, there are not.
Mr. Chair?
Yeah, I'd just like to say I support the bill. We've received an opinion from the Attorney General stating that there is no constitutional problem with the bill. Their local delegation supports it. So does the county executive. I move favorable.
There's a motion and a second. Any discussion on HB 878? Delegate Weibel.
Yeah, sorry, but there seemed to be disagreement amongst Howard County and the hearing. Has that all been resolved?
Disagreement, I'm sorry.
They didn't seem to be in agreement at the hearing. I have a note here. Is everyone on board from Howard County?
Apparently not.
Mr. Chairman?
Yes, sir.
Yeah, so it appears that all but one or two members of the Howard County delegation supports this bill. The county executive supports it, but I believe a majority of the county council does not support it. Typically, in our committee, in situations such as these, it's been our practice to stick with the local county delegation. Although I have to say, as the chairman of the committee, I always reserve the right to not agree with the county delegation if I think they made a mistake. But in this instance, I think that the prevailing practice of the committee ought to be enforced in this instance. My opinion.
Delegations in favor, but there were members of the commissioners that were not.
Council.
Council.
Yeah. Yeah.
So the council as a majority didn't support.
That's that I believe is correct.
Any additional questions?
Delegate Terraza has a question.
I didn't see your hand. Where is she?
I was just going to note the county council didn't take a vote on it, and I don't think they
Oh.
generally would. But
Okay.
I mean, I don't think it's incorrect to say that they're not all in favor of it, but I think that's just because one testified at the at one of our hearings. But generally speaking, the county council doesn't take votes on our bills.
Thank you for the clarification, Delegate Trosser. We have a motion and a second on HB 878. Any additional discussion? And there are no amendments to this bill. Any additional discussion on 878? Hearing none, all in favor of HB 878, signify by saying aye.
Aye.
All opposed? Thank you very much. HBH 78 will receive a favorable report from the subcommittee. We will now go to HB 918. HB 918 is a Montgomery County bill relevant to tenant access to cable television systems. Matthew, can you give us a discussion on HB 918 and any amendments if there are any? I'm sorry, Delegate Celebrity?
I thought it was 919.
918.
918?
Yes, sir.
Thank you.
Yes, sir. Matthew, are there any amendments on HB 918?
There are no amendments. However, there was some concern by the judiciary about the ability to actually enforce these issues under this bill in the district court, specifically because the district court wouldn't have any injunctive power. The sponsor of the bill had brought up the option of deleting that. I think it's probably better if the subcommittee would consider this as an option too, because there was a clear request or as drafted, it was supposed to be a court enforcing the provisions. It might just be best to say a court of competent jurisdiction or something to that effect.
Are there any other jurisdictions that do this?
Anne Arundel County
Anne Arundel
has
County does, yes.
language in its law, yes.
All right, Mr. Chair.
I'd like to move that suggested amendment to delete that sentence. And Matt, read that out again, the sentence that would be deleted.
Well, and what page and what line, if you don't mind, Matthew?
Let me just pull that up quickly. So on page 3 of the bill, lines 5 and 6 reads subsection F, a tenant, landlord, or cable television company may bring an action in the district court to enforce the provisions of this section. So what the subcommittee could do is say a tenant, landlord, or cable television company may bring an action in a court of competent jurisdiction to enforce the provisions of this section.
In a court, just removing district.
Well, yeah, instead of saying the district court, could say a court of competent jurisdiction.
A court of competent jurisdiction. I like
So
it.
moved.
Is there a second? All right. Any additional discussions on that amendment? Hearing none, all in favor of the amendment signify by saying aye.
Aye.
All opposed say no. The ayes have it. On the bill as amended, is there a motion on the bill as amended? Is there a second on the bill as amended?
Second.
Any discussion on HB 918 as amended? Hearing none, all in favor of HB 919 as amended signify by saying aye.
Aye.
918.
I'm 918. Yes, yes, yes. Sheila Birdie's gotten into my head. HB 918 signify by saying aye.
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 Opposed say no.
No.
It's okay, one in opposition. Okay. That is that takes care of HB 918. We'll now go to HB 1147. HB 1147. HB 1147 is real property, virtual meetings. There has been some discussions on this. On this topic, Matthew, can you give us an overview and discuss amendments on HB 1147, please, sir?
Sure. I'll mainly just discuss the amendments, but generally the bill is related to practices that a cooperative housing corporation, condominium, or homeowners association would use when conducting virtual meetings. So the amendments make it clear that the equipment and system must permit board members, committee members, or members, or basically any resident under these common ownership communities to hear and be heard by all other members participating in the meeting in accordance with the governing documents. Largely, the amendments are looking to just make clear that these are still meetings of the board. These are still meetings conducted pursuant to whatever the provisions are in the governing documents. So it's not intended to, there was some clarifying language that was put in just to clarify the sponsor's intent and protect the conditions of these meetings. There is an ability for a person conducting the meeting to mute all participants in the amended bill. And this language is consistent for all common ownership communities. Those those times when participants can fully be muted would be while the governing body is conducting business, during presentations at the meeting, and to avoid interference from background noise. However, there is a condition on this ability to mute all participants in that the participants in the meeting would have to have the ability to unmute themselves. If a participant would interfere with the ability to conduct the meeting, the person conducting the meeting or their designee would have the ability to revoke that ability to unmute oneself, and if necessary, to remove somebody who continues to interfere with the conduct of the meeting after issuing a warning to that participant.
Thank you, Matthew. Delegate sponsors, Delegate Trassa or Lehman, do you want to add anything to this bill?
Hi, thank you.
Yeah, I just want to thank the folks from CAI. I guess that's is that who you were representing? Lisa Harris-Jones worked with us on this. And Karen Strawn for working on us. And we came up with language, I think, that works for everyone.
Delegate Lehman? We have amendments before us. Is there a motion on the amendment?
Move favorable.
Is there a second on the amendments?
Second.
Any discussion on the amendments? All in favor of the amendment signify by saying aye.
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 All opposed say no. On the bill as amended,
Move favorable.
is there a second on the bill as amended?
Second.
Second.
Is there any discussion on the bill as amended? All in favor of HB 1147 as amended signify by saying aye.
Aye.
All
Aye.
opposed say no. Ayes have it. HB 1147 will receive a favorable recommendation from the subcommittee. We'll now move on to HB 1295. HB 1295. HB 1295 is a bill that speaks to multifamily dwellings and smoking policies. And what the bill does is establishes Matthew, why don't you give us an overview of a brief overview of the bill, and there are several amendments that need to be discussed as well. Matthew, you have the floor.
Sure. So the amendments generally would require for certain multifamily dwellings, the establishment of a smoking policy for the building. The policy would include locations where smoking is authorized, locations where it's prohibited, any conditions on the ability to smoke in areas where it's authorized, a process to file a complaint against an individual who violates the policy, and penalties or fines for violating the policy. So this would require establishment of a policy alone. Now, the amendments, and I have to apologize to the subcommittee, I did not have time to do this in a official form. I had to handwrite the amendments. So I sent a document out earlier, and the title is House Bill 1295 as amended by Michler. And then there should be an arrow that says for Delegate Washington. I'm going to pull those up now because I think it'd be easiest to speak from them, but they go to addressing some of the AOBA concerns and about use of apartment building or application of the bill to apartment buildings. While I'm pulling that up, I believe Erin Bradley should be on the line. She might be able to kind of discuss what some of the general concerns were.
And also, before I get to you, Mr. Chair, Erin, I want to make sure that we all understand that your concerns have been addressed. You take the floor. Erin, you have the floor.
Sure, thank you. Yes, we appreciate the Matt's work and the sponsors' work. Our concerns have been addressed. And in speaking with the sponsor, he indicated his intent was really to get at condominium communities. And so we just wanted to make sure that we got two condominium communities, common ownership communities, in a way that it was unambiguous that apartment communities were not intended to be covered with this bill. And we appreciate Matt's work on that and the sponsors' work in addressing those concerns.
Thank you, Erin. And I want to make sure we all understand what this bill says. This bill says that there must be an established policy. This bill does not dictate where you can or cannot smoke. This bill simply says you must establish a policy. Delegate Trassa.
Thank you. I thought Wasn't
ahead,
the
Fran.
chairman? I thought the chairman had, Mr. Chairman had his hand up. Okay. So I'm just curious, is the reason that you don't want it to apply to apartments that they would have their own policy?
Yes,
Oh, okay. Thanks.
currently have policies. Thank you.
Okay.
Delegate Healy.
I just have a couple of questions. Does this apply just to tobacco, or is it also going to apply to cannabis as well?
It would, so let me go to the definition in the bill. Again, I apologize for having a scroll, but it would smoke or smoking as used in the bill would mean the inhaling, exhaling, burning, carrying of any lighted matter or lighted substance that contains tobacco, any other leaf, weed, plant, or other products. So I think that could arguably get to cannabis. Weed or the use of something to use vaping liquid. And some of these definitions are pulled from other places in law. It's kind of to make a consensus definition of what smoking might mean under the bill.
And let me just, if I can remember, I thought the discussion during the bill hearing was about people who had purchased a condominium, spent a lot of money, and then had neighbors smoking and making their lives miserable. Is that because there was no policy?
And not to cut you off, Delegate Healy, but again, the whole purpose of this bill as amended is for the organizations to set a policy. That's the whole purpose here.
And they would have to stick by the policy once they've set it, right? I mean, if I decide that I buy a place because I think they have a no smoking policy and I don't want smoke, and then they change the policy and allow smoking, that makes it a bit difficult for me to enjoy my property. So I guess that's the question: is once they establish the policy, how often can they change it?
So the bill is silent as to whether or not they can change it, although it would just be a policy of the community. I would imagine, depending on whatever the
If you look at the Condominium Act, the Condominium Act specifically states the number of votes required to change bylaws, et cetera. So if a policy were to be changed, it would have to be done in accordance with the Condominium Act.
Okay.
In terms of number of votes.
it would depend on how the policy was adopted. Yes.
How cool would it be to change that word weed to pot? But anyway, Mr. Chair, you have a question?
No, I just wanted to say the reason I like this amendment and I like this bill is that in a rental community, the landlord has the ability to enforce non-smoking either by evicting the tenant or by not renewing their lease. In the case of a condo community, you're stuck with the people who buy property. And so I think this kind of law is very, very necessary, whereas not including apartment buildings shouldn't be included because, as a renter, I don't own the property and I could be evicted if I start doing bong hits in my apartment, which of course I would never do. So that's the only thing. That's why I support the amendment and the bill.
Delegate Terrasa and Delegate Healy, can you lower your hand if you don't have any additional questions?
Yes, I'm finished. Yes.
Thank you. Delegate Terrasa?
I guess I'm concerned about including weed in this bill because are people able to smoke weed, going to be able to smoke weed outside and out and about, or they're going to have to do that in their homes?
If someone has a medical reason to smoke such an entity, then they have a medical certificate that says they have the right to. Now, I don't know about that word weed, and I was just kidding when I said pot. I didn't mean to stir any additional comments. I'm sorry.
I'm just wondering if cannabis shouldn't be excluded from this bill, because I'm just concerned that as we're developing policy about cannabis, if people are only allowed to use it in their homes, like if we don't have public places where they're allowed to use it, then you're talking about people in condos, and you're banning it, then some people in condos won't be able to use it. And only people in single family homes will be legally allowed to use it.
I'm so sorry for me putting that word potty in. I was only kidding.
No, but I am concerned about that. And I was concerned about that during the testimony.
All right, Delegate DFH.
Yeah, on that same note, I get what Delegate Terraza's concern is, but I would say if you are living in a condo and you're in a unit next door or the following unit across the hall and you smell cannabis, that is I've just like 2 weeks ago, I was in the elevator at the Westin, and a couple got on that elevator, and the smell was breathtaking. It was overwhelming. I can't imagine living across the hall from somebody that's smoking marijuana and then not having any recourse whatsoever to deal with that, whether it's smoking, tobacco products or marijuana. Like, there comes a point where you should be able to live your life. And if all of that smell is coming under your door or coming through your HVAC system, like, I don't have a problem. I don't have a problem with that, with keeping it in the same posture as tobacco. It can be just as annoying, even more so, especially if you have kids and you have to explain to your kids why you're smelling marijuana all day inside your own apartment, or I'm sorry, inside your own unit, your own condo unit, not apartment, but condo unit. So I just wanted to say that.
Delegate Trosser, you wanted a second bite?
Well, just to follow up, the difference is that there will be places that you can smoke cigarettes, but
That's
there may
correct.
not be places that you can smoke marijuana.
Well,
So that may be something that we have to deal with in that policy and not here, because I do appreciate what you're saying about that. And I'm not saying it needs to be that you can do it in your apartment next door to somebody else, but I don't imagine there's going to be cannabis smoking sections.
Well, according to the language, as Matthew already read, it says tobacco or any other leaf, weed, plant, or other products.
That would be cannabis.
So it's already there.
No, what my concern is, if we allow communities to ban it and there's no other place that you're allowed to smoke cannabis, then people in condos may not have any right to smoke. So maybe we need to deal with that in
No.
No?
Oh, I'm sorry. I shouldn't have interrupted you.
All right.
One thing about cannabis I do want to point out, because I think it's important for the subcommittee. There were two other amendments that I would need to discuss, but on the topic of cannabis, the policy has to be consistent with, this is language about the Natalie M. Leprade Medical Cannabis Commission. So I think it would address, at least with regard to medical cannabis, would have to be consistent with the use of medical cannabis.
Thank you, Matthew. DFH, if you're finished, could you lower your hand? And Delegate Trosser, could you lower your hand if you're finished? Mr. Chair, you have your hand up.
Yeah, I just want to say, I have nothing against people smoking marijuana. I think it should be legal. I have nothing against people smoking cigarettes and cigars. I think that should be legal. They should have the right to smoke those things as far away from me and my wife as possible. And I know it's terribly unfair that if you own your own single family home, hell, you can have a bonfire in your courtyard. But if you live next to people, no, I don't think you have the right to smoke marijuana. If you are in a building where the rules going in said you're not supposed to smoke in the building, and you knew that when you're going in, no, I don't think you have the right to smoke marijuana, even if you medically need to, because I have rights too. I have the right to not smoke marijuana. And I think that right is every bit as strong as the right of somebody else to smoke, whether it's marijuana or tobacco or hashish or whatever. So that will be the last thing I have to say on this.
Mr. Chairman, be careful. Your NIMBY is showing a little bit.
Oh, yeah, you're right.
and that's exactly why this legislation is very specific, that a policy must be constructed. Delegate Trosser.
Yeah, just to clarify, I don't disagree with that statement at all, Mr. Chairman Barve, just to be clear. I do completely agree with that. And that's why if I were crafting a policy for a condo association, I'd have them smoking in a very far off section of the community that wasn't near any buildings. And so maybe this just needs to be addressed as we start to address cannabis legalization, how you can have some place that somebody is allowed to smoke it.
And that's what this does.
I agree. Well,
It's
right, but they could also just ban it. And the problem with, unlike cigarettes, you can't just smoke it somewhere else if cannabis is only allowed to be smoked in a residence, for example. But it's fine. I'm going to let it go, and so we can move on, because I know we have other bills to get to. I think I've said my piece.
Did we get a motion and a second already, or?
Yeah, I think we did, but
I thought so too. We got a motion and a second already.
On the amendment, right?
On the amendment. Yes, that's correct. Are there any? I'm sorry, Matthew. Go ahead.
Sorry, I'm reviewing the amendment now. reviewing my notes, and there was one more portion of the amendment I just wanted to highlight, and that's what's on the screen now. That nothing in this section may be construed to limit the rights of a governing body or tenant or residential owner to initiate or defend against civil actions or preempt a county from creating, enacting, and enforcing its own smoking policies in these dwellings that are more stringent than the policy. So it's not meant to preempt counties in any way.
Thank you, Matthew. We have a motion and a second. Any additional discussion on the amendment? Hearing none, all in favor of the amendment signify by saying aye.
Aye.
All opposed, say no. The ayes have it. On the bill as amended, if a
Move
motion
favorable.
is there a second?
Second.
Any discussion on HB 1295 as amended? Hearing none, all in favor of HB 1295 as amended signify by saying aye.
Aye.
All opposed? Thank you very much. HB 1295 will receive a favorable report from the subcommittee. We will now go to HB 551, Delegate Wells. This is Delegate Wells's bill. Matthew, a folder out here. This bill, ladies and gentlemen, is relevant to real property residential leases, and it's a notification. Pardon me. Delegate Wells has been working very diligently on this bill, and we have several amendments. Matthew, if you could take us through the amendments. It's 4:45. Matthew, if you could take us through the amendments on this bill, HB 551, I certainly would appreciate it.
Yes, sir. So I would just note for the subcommittee, the bill has almost completely been changed. I'd like to emphasize it's not about rent restrictions anymore. It is about notification of rent increases. So the amendments strike the body of the bill and simply require that, sorry for the scrolling, that they note that this section only applies to a residential lease for a term of at least 1 year, and that a landlord must notify a tenant in writing and through electronic mail at least 90 days before increasing the tenant's rent by more than 4%.
Move the amendments.
Is there a second on the amendment?
Second.
Any discussion on the amendments? Hearing none, all in favor of the amendment signify by, I'm sorry, Delegate Weibel. Delegate Weibel has a question on the amendments.
Yeah, why is it electronic and mail? I mean, why wouldn't one form or the other be sufficient?
Uh,
I think Delegate Wells would probably have to speak to that, although
I believe that's what that was put in the language last year around notice for failure to pay rent process.
and I think it's a good backup as well, Delegate Weibel, tell you the truth. Kathy Howard, you want to speak to that?
I was just going to say that not every tenant and every landlord has electronic email or other kind of stuff, electronic communication. So an or there would be better, or some kind of qualifier if after electronic mail, if available, something to that effect. Because that's I know that I would say good 75% of my my tenants do not have an email address.
Well, if there is, I'm sorry, Mr. Chair.
That you know of.
Yeah. So if so,
Correct.
but Kathy, currently there's an and in there, if I'm correct, right?
Yeah. Why could it be? I mean, right here's a letter from one of my constituents, does not have email, and he cannot be an EMT in the state of Maryland because the only way he can be that is if he has an email address. So, you know, there are people that don't have the ability to correspond electronically.
I got, don't get excited, Delegate Weibel. Hang on. Hang on.
I'm not getting excited. It's just a simple and or. I mean,
It's changing me more. I guess if or makes more sense. I mean, I think that if someone doesn't have an email address, then they don't have an email address on file. So there's nothing to email.
The suggested amendment is that the and be changed to an or. Is there a second?
Second.
All in favor of the and change to or, signify by saying aye.
Aye.
All opposed, say no. On the other amendments that we have been,
Yeah.
I'm sorry, I can't hear you.
Wait,
I'm sorry. I'm
So
sorry.
they would do email or?
Yes.
I'm opposed to that.
Okay, so that amendment and that amendment changing and to or has been passed. Now we're on the other amendments. There a motion and a second on the rest of these amendments on HB 551. Is there a motion?
Move favorable.
Is there a second?
Second.
Any additional discussion on the amendments to 551? No, hearing no discussion on the amendments to 551. All in favor of the amendments to 551, signify by saying aye.
Aye.
All opposed? The amendments carry. On the bill as amended, is a motion to approve the bill as amended, please?
So moved.
Is there a second on, is there any discussion on HB 551 as amended? Hearing none, all in favor of HB 551 as amended, signify by saying aye.
Aye.
All opposed? The ayes have it. HB 551 as amended will receive a favorable report from the Housing and Real Property Subcommittee. Ladies and gentlemen, it's now 4:47. We have to be back on the floor at 5 o'clock. We have one bill left, HB 140, which we will not be able to take care of in 3-4 minutes. Therefore, ladies and gentlemen, this HRP meeting is adjourned and we will convene again to take up HB 140 and other bills as well.
Okay.
Thank you.
Bye-bye.
Sound like McLaughlin.
That's what it's supposed to.